Today I'm going to talk to you about retirement plans and specifically how to protect those through a retirement plan trust. Another title for this speech would be How to Protect Your Family Without Having to Give Up Control. Because one of the things I talk to you about in almost every speech that I do is the sooner you plan, the sooner you put things in place, the more control you can maintain over what happens to you and what happens to your assets. So, what you're going to discover is ways to promote family harmony, how to leave a legacy, so how to leave your money behind in a way that it doesn't ruin the people that you're leaving it to, how to save taxes on your retirement plans. This is for you if you're worried about your children getting along after you're gone. Now, I don't have a magic wand. I can't fix it if they don't currently get along, but I can at least help you make it go as smoothly as possible for your family. If you're worried about the taxes that'll be paid by you or your family on your retirement plan, I'm going to talk to you about how to save those. And if you're sick and tired about worrying about your family altogether, and if you're confused by conflicting advice, now nowadays we can search on the internet and we can find information on absolutely everything. We've also got this wonderful AI that does many good things for us. But one of the things that it should not be trusted for is for creating legal documents, especially wills and trusts at this time. I just went to a conference for attorneys, and one of the things we learned in the conference was there was two different attorneys that lost their right to practice law. And the reason why they lost their right to practice law is they counted on AI to do their job. So what they did is both of these attorneys relied on artificial intelligence to create a brief that they submitted to two different courts. In that brief, the artificial intelligence wrote this really well worded, brilliant brief that cited cases that did not exist. And so the attorneys submitted those to the court as actually the law, and they actually got in trouble with the judge because they didn't double check the artificial intelligence to make sure what it was putting out was accurate. They say that 2 out of every 10 wills created online work properly. In the last couple of years, we've actually probated the 8 that do not work. And all 8 of those cost the families thousands of dollars more than what they would have had to spend with a properly drafted will created by an attorney that was customized to their family. So imagine having the peace of mind knowing your family is going to get along, or at least that you haven't made a situation with your family worse than it currently is. Knowing that you and your family are going to save as much as possible in taxes, and having a plan customized to your unique family situation because every family is different. So a little bit about our firm. We've helped over 6,000 families protect the assets that they leave to their loved ones from divorce, creditors, and lawsuits. We've also helped over 300 families implement the plans that we've designed after a loved one passes away. We've also helped over 1,200 clients implement the plans that other attorneys have designed. And the reason why that's significant to you is for most of you, putting together an estate plan is relatively depressing. So your temptation is going to be to put it together, put it on the shelf, and forget about it. But what's important to you is it actually works when it's needed. And the fact that we've walked along over 1,500 families after they've had a loved one pass away and made sure it goes as smoothly as possible for them lets you know that we have the experience to have that done. The other thing that's unique about our firm is we do both estate planning and elder law. So estate planning is what we're going to be talking about today with talking about retirement plan trusts. Elder law is Medicaid and benefits for special needs. We also belong to professional organizations of over 3,000 attorneys nationwide. So you get the experience of not only the attorneys in our office, but also other attorneys nationwide. So that way we can learn from the experience of those other attorneys in customizing what we put together. And we've relied a lot on the other attorneys in the organization to understand the new Secure Act to make sure that our current retirement plan trust is up to date regarding the new laws. We have 3 locations if you'd like to meet with us. We have an office in Denton, an office in Bartonville, and an office in Aubrey. I have 3 books I want to talk to you about. My first one is Who Gets Your Stuff When You Die. So that's my most popular book. It's the one we've had out for 15 years now. It's the one that I give the most speeches on. If you want a copy of any one of these 3 books, you can call our office and ask for them. Who Gets Your Stuff just covers a little bit about all the different estate planning things that you might need. Second book is What Your Spouse Should Know If Something Happens to You. Because a lot of times in marriages, there'll be things that one of you does that the other one doesn't know how to do, or doesn't know the passwords or codes to get into things, doesn't know where the finances are. This book has a series of checklists. Those checklists are also on the website if you want to download them from our website. And the last book is Living with Alzheimer's Disease. It's entitled Finding Strength in the Face of Alzheimer's. And the reason why I wrote this book is I actually had 2 clients that died who were taking care of their husbands. So both of these ladies actually died from pneumonia, but I think they actually died from exhaustion. They actually say 60% of caregivers for somebody with Alzheimer's actually die first. And both of these ladies are a good example of that because they really did become extremely exhausted taking care of their spouse. So I'm going to talk to you today about your biggest problem asset, your retirement accounts. And in a minute, I'll talk to you about why that can be the biggest problem asset. It is most likely the largest asset you're going to leave behind because most of my clients complain about having to take the required minimum distributions. They don't like the idea of paying income tax on the money. And so they try to defer it as long as possible. So it is the most likely asset that you will leave behind to your loved ones. So by the way, when I talk about retirement accounts, I mean traditional retirement accounts. I also mean Roth IRAs. So Roths are the ones that you pay tax up front, and then when you pull it out, you do not have to pay income tax. The other advantage to Roths is the fact that you do not have to take minimum distributions during your lifetime, and your spouse does not have to take minimum distributions during his or her lifetime. I'm also talking about 401ks, 457s, 403bs, Keogh plans, and any other retirement plan where you put money away and pull it out in the future. So let me talk to you about the problem. There's a potential double taxation. So when the retirement plans go to your beneficiaries, if you have over the federal estate tax exemption, there can be a tax up to 47% of that money. Now the current exemption is high enough that it doesn't apply to most people. So current exemption is 15 million. If the current laws sunset in 2025, then in 2026, the estate tax exemption will be 7 million. And if it was subjected to this estate tax, almost no matter what, whether you are in excess of the estate tax exemption or not, it's going to be subjected to income tax. And income tax can be up to 35%. Now, when they combine these rates, they give you a little bit of a break. So when you combine the two numbers, it's larger than 71%, but they actually do tax it currently at 71%. Now, I had a lady many years ago. She inherited a $3 million IRA from her father. That $3 million IRA, because the exemption was currently $1 million, the extra $2 million was taxed at 50%. So there was about $1 million in estate tax on that $3 million IRA. Also, when she pulled the $3 million out of the account, there was $1 million in income tax owed. And during that period of time, there was actually an excise tax. So the excise tax said if you take out more than a certain amount in a year, you actually have to pay excise tax on it, and that's a 15% tax. So out of the $3 million IRA that she inherited from her dad, she received less than $1 million. So I'm going to talk to you about some ways that we can avoid that tax. Let's talk to you about tax-wise is something called an IRMA bracket. So for Medicare supplements, if you make too much money in a year, or the year you go on Medicare, or any of the years you're on Medicare, there's an IRMA surcharge. So it's an extra charge for your Medicare that other people don't pay. So in the event you exceed the amount of income that they feel is appropriate for you to have during retirement, they're actually going to charge you more for your Medicare supplements than they charge other people. And if you end up falling in one of these IRMA brackets, you can actually end up paying $500,000 more in Medicare supplement charges than what other people pay. I'm going to talk to you a little bit about the Secure Act. So the Secure Act was passed in 2019, became effective in 2020. And one of the purposes of the Secure Act was to encourage people to convert to Roth IRAs. And one of the encouragements was this IRMA surcharge. So if you were to convert to a Roth IRA and weren't required to take minimum distributions, you can avoid this additional charge on your Medicare supplement. But I'll talk to you a little bit more about that in a minute. So the RMD rules, the new RMD rules, allow you longer income tax-free compounding after you're gone. They also allow longer tax-free compounding while you're here. So under the Secure Act, they actually changed the age for the required minimum distributions to start. So prior to the Secure Act, everyone had to take out minimum distributions when they turned 70 and a half. Now that the Secure Act has been passed, there's a Secure Act and there's a Secure Act 2.0, and there's actually a proposed Secure Act 3.0. Under the current Secure Act, if you were born prior to the year 1960, your required minimum distributions begin when you turn 73. And if you were born after 1960, your required minimum distributions start when you turn 75. And there's actually a proposal under the Secure Act 3.0 to make that age 76, which means that money is going to have longer to compound tax-free before distributions are required to be taken by you. So the next question is tax-free compounding after you're gone. So under the Secure Act, after you're gone, your beneficiaries, most beneficiaries, are going to be required to take the money out over a 10-year period. And in a minute, I'll talk to you about some exceptions to that, but the exceptions are very narrow. So on your retirement plans, you have choices as to how you can put together your beneficiaries. You can name individuals as beneficiaries, but naming individuals as beneficiaries may create problems. The first problem it might create is beneficiaries can decide to cash out earlier than required and blow the stretch out. So if they have 10 years to take the money out, if they choose in the first year that they inherit to take all the money out, they're going to be surprised in January by a 1099 showing that they owe income tax on all that money. It would be much better most of the time tax-wise for them to take distributions over a 10-year period. Now, this is something that definitely the beneficiary should consult with an accountant and their financial advisor to make sure they're making the correct decision as to how to take the distributions. So one of the reasons why they might take the money out all at once is they might not be aware of the rules and choices. I actually had a client, he inherited a $250,000 IRA from his mother. He went to his financial advisor and he asked them what to do. And the financial advisor said, well, if you'll bring us a death certificate, we'll give you a check. So he took the check, he cashed the check, and he invested the money. And then he discovered that it would have been much better to take the money out slowly. Unfortunately, once this money's pulled out, there's no way to put it back in. Now, if you were to pull money out of your own retirement account, there's a period of time you can put it in without any tax consequences, but inherited money, once it gets pulled out of the retirement accounts, there's no way to put it back in. Also, the other reason why they might end up blowing the stretch out is if it's a corporate plan that requires a payout in 1 year, regardless of the stretch out rules. So a 401k or any other company plan, they can have their own rules as to when you have to take the money out, and that might mess up the ability to take it out over a period of time. Most financial advisors will tell you if you're no longer working for a company, your money should not still be invested in their retirement plan. There's a lot more flexibility if you roll it out into a retirement plan that you can control. The worst thing your beneficiary can do is roll the retirement account into his own retirement account. What will happen with that is they will owe income tax on all the money. Plus, there's a penalty for an improper contribution to a retirement account. And the last reason why they may not stretch it out is the beneficiary, his spouse, or a third party may just want to spend it. And I think I've told you before in many other speeches, most inheritances are treated exactly like lottery winnings. So the odds on your beneficiary spending it within 1 year is pretty high. How many of you think at least one of these apply to your beneficiaries? The wrong people eventually inheriting the assets. So if you were to leave an asset to your daughter and she was to pass away, she probably would leave it to her husband, and her husband's probably going to leave it to whoever he marries next. So it may not end up going to your grandkids. For spending habits of the beneficiaries, their spouse or children. For money management skills of the beneficiaries, your beneficiary's spouse taking some if they ever get divorced. A young, elderly, or disabled beneficiary unable to manage their own affairs, or a beneficiary losing their government benefits. So if you have a beneficiary who's on government benefits, so if you were to have a nephew who's living in a group home and is on Medicaid for his medical expenses, he's not allowed to have more than $2,000 in his name. If he inherits more than $2,000, he's actually removed from those benefits. Lawsuits, creditors, or even bankruptcy could grab the IRA. And then estate taxes when they pass it down. Now, the exemption I told you a minute ago, exemptions right now are really high. But if you think about the amount of money Congress has spent And eventually they're going to need to do something to raise some revenue, which means they're going to have to cause taxes to happen, which means that exemption is very likely to come down in our lifetime. And it's extremely likely to happen during our kids' lifetime. So how can you maximize both the stretch out and protection for your family? Naming a living trust as a beneficiary will not work. So the retirement plan trust, what is it? It's a revocable trust, meaning it's changeable. You can make adjustments to it during your lifetime. It's established by you now as the account owner, and it's the beneficiary of the retirement account when you pass away. We keep it separate from the living trust, and in the next slide, I'll talk to you about why we keep it separate from the living trust. So why can't I just put it inside my living trust? The required retirement plan trust provisions often contradict those in the living trust. The big risk is that there'll be a 5-year required minimum distribution rule if the language isn't done properly. So the IRS has some very strict rules about what's considered a designated beneficiary and the language that needs to be put into a trust in order for you to qualify as a designated beneficiary. And we've got to make extra sure that that doesn't contradict other provisions inside the trust. That's why it makes more sense to have a separate retirement plan trust. Also, the separate retirement plan trust alerts your beneficiaries to the special treatment of your retirement funds. Talked to you about it a minute ago, about the fact that we want to make sure that they don't take all the money out all at once. They take advantage of the fact that they have 10 years to get the money out of the retirement plans. This allows the money to compound tax-free longer, usually ends up with a better tax benefit for the beneficiary. Also, retirement plan trust is easier for the custodian, meaning whoever you've got your IRAs or retirement plans with, to read, understand, accept, and properly administer. So how the retirement plan trust works is your IRAs drip into the trust through required minimum distribution. So those are the amounts that the IRS requires that you take out each year. They come into the trust itself. They have the protection of the trust, and then they pour out to or go out to the beneficiaries. Most beneficiaries will actually be paid the required minimum distributions as they get distributed, but some will have them withheld. So in the event you have a beneficiary who's not good with money or who's on government benefits, it might be better to have the money stay in the protection of the trust. And the trust will actually have flexibility regarding that. So let me walk you through a short case study. These are our clients, Bob and Betty. So the way the retirement accounts can either be worded is either we can have Betty as the primary beneficiary or we can have a trust as the primary beneficiary. And I'll talk to you about that in a minute. The secondary beneficiary is the kids. So initially I'm going to talk to you about if we don't have a retirement plan trust and it goes outright to everybody. So Bob's retirement accounts go outright to Betty and the secondary beneficiary is the kids outright. So in that situation, Bob Jr. has a high maintenance spouse. She's likely to want to spend the money. They're also a little concerned that if she leaves their son, that she might end up taking the money. He's also in a profession where he's likely to get sued. So they're concerned that if he gets sued, he might lose his inheritance. And if he's successful enough to have enough money to be above the estate tax exemption at the time when he passes away, and I mentioned to you earlier that probably during his lifetime, the exemption is going to come down from the current high number and be closer to the 1 million that I gave you as an example earlier on. And so in that case, anything over that $1 million would be taxed at about 50%. So this is leaving it outright. It could be gone to all three of these things. So Jane is the middle child. She lacks the financial experience to handle the money. So she might end up not investing it wisely or spending it. She's also got a problem marriage, but actually, to be honest with you, she doesn't have a problem with her marriage at all. It's her parents that have a problem with her husband. They just really don't like him. And so they're concerned that if they give it to her outright, most likely if she passes away, she's going to leave it to him. And if she leaves it to him, he's probably going to leave it to his new wife, which means it doesn't end up going to those precious grandkids. Now they have a youngest child, Joe, and some of you have a Joe in your family, and Joe could have any name, but just the name we've given him. So Joe is the child that never quite gets it right. So he's the kid who's maybe soft-hearted, vulnerable to other people taking advantage of him. He might also have some sort of disability, but he needs to be protected against himself. So if you were to give him to him outright, and a lot of people lot of my clients will say, well, we want to be fair. We gave Bob his money outright. We give Jane her money outright. We have to give Joe his money outright. But if you think about it, if he's not responsible, you're actually making it where the money is not going to be there to protect him or take care of him. So will your retirement accounts be properly protected from your loved ones losing their inheritance to unwanted third parties or to the federal government? So what we recommend is that the retirement plans, you create a retirement plan trust. The initial beneficiary is your spouse. Now, for a lot of my clients that are concerned in making sure that their spouse actually leaves it to the children, they'll actually have the retirement plan trust create a marital trust, a trust for the benefit of the spouse. Spouse can spend the money on anything they need or want, but whatever's left has to go to the kids. But that's an option we can talk through when we meet. The secondary beneficiary would be the trust for the benefit of each of the children. So in this situation, we divide it into 3 shares. Bob's in charge of his share. It'll be protected if he gets divorced, if he ever gets sued, and from that second estate tax if he's successful enough to have enough money to be subjected to estate tax. Now for Jane, we did a little bit more custom drafting. So we talked through it. They're not really concerned about Jane blowing the money. What they're concerned about is making sure she chooses the right financial advisor. So what we've done in the documents is we've actually said that Jane needs to use her parents' financial advisor or one with similar credentials. So that way they're sure that she's getting good financial advice in how she invests. We've also added in language with the Heritage Trust to make it where it's protected if she were to get divorced. We've also got language in there that on her death, it goes to the grandkids. So she does not have the option to leave it to her husband. And then we get to Joe. And again, we come up with what is fair. So one of the things we need to think about with Joe is, does it make sense for him to be in charge of his own money? Is he going to be vulnerable to giving it away? And then the next thing that most of the time happens when we talk about Joe is people want to put his brother Bob in charge. But if you think about it, if Joe is constantly asking Bob for money and Bob is constantly telling Joe no, what is that going to do to their relationship? So I always talk to people about, do we want to preserve the relationship between the two and have somebody else be in charge? Or do we think that they can get along well enough for this to happen? But if we have it inside a Heritage Trust, we can protect it if Joe gets sued. If he ends up ever being on government benefits, we can protect those. So the Heritage Trust, which is the layer of protection where a beneficiary can be their own trustee or have somebody else protect it for them, is now recommended equipment in every living trust we build. And in a lot of my speeches, I use the car analogy. And if you think about it, modern cars have a lot of safety features. So this is really a safety feature for your beneficiaries. Now, for some beneficiaries, it won't be needed. They will never have the situation where they get divorced or sued or have creditor problems. But the safety feature doesn't hurt to be there as a protection. So similar in modern cars, we have backup cameras. We have our car beeps if we're getting ready to change lanes into somebody else. It's just a way to warn them or protect them in case something happens. So let me summarize what we've covered so far. The benefits of a retirement plan trust is we can maximize the income tax deferral and wealth accumulation to take advantage of the stretch out. And we can do this even for Roth IRAs. We can protect the undistributed balance. This is also for Roth IRAs. We can make sure that we get proper distribution to your intended beneficiaries, meaning it goes from your kids to your grandkids. We can protect against the spendthrift. So the spendthrift is the kid that spends too much money. It's not someone who's thrifty. It's someone who's, if you gave them money, they would actually spend that money and then charge extra money on the credit card. We can add in professional money management the way we did for Jane. We can add in divorce protection. We can also do protection for minors. So if somebody's under the age of 18, protection for elderly or disabled, government benefit protection, lawsuit, creditor, and bankruptcy protection, and we can minimize the estate tax. And perhaps the greatest benefit is a legacy in your name. So every check they receive from the retirement plan trust will still have your name on it. That will remind them where the money came from, how hard you worked to accumulate it. So should you get a retirement plan trust? You have a will or living trust to properly distribute and protect all of your other non-retirement accounts. The retirement plan trust is a living trust designed specifically for retirement assets. Now, a quick warning, it's not one size fits all planning. You should consult with an attorney and a financial planner to see what makes sense in your situation. And make sure you're working with one that's familiar with retirement plan trusts and how those work. So the retirement plan trust must be properly done to meet all the IRS technical requirements for a designated beneficiary. Plus, they need to coordinate with your overall estate plan. We may need to make some changes to your other documents, like your living trust or will. And we may want to do a consistent planning approach. So we may want to change the trustees you currently have on your living trust. We may want to change the distribution pattern, and we may want to upgrade both your living trust and the retirement plan trust to have this heritage trust, which is the protection against the divorce, creditors, and lawsuits. So where do you go from here? What I've found from experience is most people procrastinate because it's kind of depressing to talk about. But the sooner you put this together, the more control you can maintain, the more protection you can have for your family. We would love to meet with you to discuss how we can protect your family. You can contact our office to schedule a time for us to meet at any of our 3 locations.